Right.
The thing on the application of FMA and others, and the security of
Let me move this light so I can see you all. Yes, Mr. Butler.
My Lord, I appear with Miss Mitchell for the claimants, my learned friends, Mr. McGahey, King's Counsel, and Mr. Fulbrook for the Secretary of State, Mr. Ahmad, King's Counsel, and Mr. Lewis as special advocates.
Right, so just get that right, because I've not got all the details. So you and Miss Mitchell for the appellants, Miss McGahey and Mr. Fulbrook, and the special advocates, Mr. Ahmad and Mr. Lewis. Is that right? We haven't got all the details on our sheets, but that's good. Thank you very much. Now, what can you tell us about the recent developments, Mr. Butler?
I don't know as much as others in the court. All I know is that we have been told that on Friday, disclosure was given by the Secretary of State to the special advocates, and the court and the appellants were notified that that had happened.
Yeah.
Yesterday evening, a Section 8 application was made, which is now before the court.
Yeah.
Could I don't know whether the court wants to hear from me now or wants to hear from the other parties first, but at some point I'd like to set out the appellant's position in respect of that application and where it should take this appeal.
Okay, so I suppose what we should do would be to hear the application. Is that going to have to be in a closed session if we hear it?
I think it will have to be.
Okay. And then you'd want to respond in some way.
Well, to give the court the punchline of our position, we have to accept the judgment of the special advocates that this material is relevant to the substance of the appeal and that it materially improves the appellant's prospects on the appeal. And in those circumstances, I support the application for an adjournment.
Yeah. Yes, well, I note the way you put it, the substance of the appeal. By that, do you mean the specific issue on this appeal as currently put before us on the ground? I mean, the various ways you could have challenged the decision below, but you've challenged one particular aspect of it.
Yes.
Is that what you mean by the substance, or do you mean the decision more broadly?
Well, can I deal with that in stages? The special advocates say in their joint notes with the with Counsel for the Secretary of State for the Home Department, they say at paragraph 3 that they've asked the Secretary of State to remake the decision under challenge in light of the material. Now, that wouldn't, in my submission,
Sorry, paragraph 3.
paragraph 3. In addition, the
Yes.
essays consider that the material is relevant to the question of whether the respondent should
yes.
remake her decision.
Yes.
Now, that wouldn't, in my submission, warrant an adjournment, because the proper interpretation of the conducive policy would be relevant to any redetermination, if nothing else.
Yeah.
But paragraph 2 of the note, final sentence, indicates that the special advocates have concluded that the information increases the appellant's prospect of success in the appeal.
Sorry, just where are you reading that?
I'm taking the last sentence. In the view of the special advocates, the material is relevant to the appeal.
Yeah.
And we're told elsewhere in the note that it's only of assistance to the appellant, not to the respondent.
Preceding sentence in paragraph 2.
Yes.
It does say paragraph 3 in addition.
Yes, quite.
Yeah.
So.
And I think this is, I'm sure this was written with great dedication and care, but it may well have been written quite hastily. Mr. Butler, we must be careful not to treat it like a statute.
No, well, I can only proceed on what's written,
Yeah.
and I accept that. I accept those notes of caution. Now, read literally, paragraph 2 suggests that this material bears on the ground of appeal that is advanced by the appellants. But if it is not written with the care of a statute, then it's possible that there are additional grounds of appeal that we don't know about, which the special advocates propose to advance. So it looks like we're talking either about something that bears on the ground of appeal that I'm proposing to advance, or there's an additional ground of appeal against Mr. Justice Swift's judgment that I don't know about. But either way, if either of those things are right, then it's plainly in the appellant's interests for there to be an adjournment, so those points can be put.
All right. Thank you. So at that point, would you like us to have a closed hearing now in which we hear from Mr. Ahmed? Is that what you're suggesting?
Yes, well, what I was going to suggest in terms of consequential matters, first, there clearly needs to be a hearing of the Section 8 application. Now, whether that happens today or whether it happens soon after today, I think is a matter for the court. The second thing that we seek, and perhaps the most important, is the relisting of the substantive appeal.
Well, I was going to raise that point because we're very aware of the predicament your client is in and his family, and I imagine you were going to take that point.
Yes,
so what do you say about that?
Well, could I ask the court, and the court will no doubt have already seen this, could I ask you please to turn up the core bundle at tab 3, page 16, which
I
is
should say we have read that. We've read the full one.
yes, which is a commission decision by Lady Justice Andrews.
Yeah. Yes.
And if the court would please note the second reason
Yes.
she gave.
Yes. Absolutely.
And it's for that reason, right at the bottom of the page, that Lady Justice Andrews directed it to be listed as soon as practicable in Michaelmas term.
Okay.
Now those reasons hold good now, and if anything, we say they apply with even greater force given what appears to be entirely unjustified delay on behalf of the Secretary of State. And so we would, if the court can accommodate it, we would ask that this hearing be relisted this term.
Yes.
Council have discussed dates that council can manage. Of course, we're in the court's hands as to what the court can manage, but possible dates would be the 14th and the 15th of December. That would give the special advocates the 4 weeks that they seek, and would give us, our side, a fair opportunity to consider any new material and to rework the case as necessary.
Okay. Right. So, and do you? Okay. Anything else you want to say?
Well, there are then consequential matters which are of secondary importance, but I might as well just
Yes.
put them on the
Put
agenda
your cards
now.
on the table.
So 1 Section 8 application, 2 relisting of the substantive hearing. Third, there's the question of costs thrown away, common ground between the parties that the Secretary of State should pay those costs on the indemnity basis.
Or that's agreed, is it?
That's agreed. And then, sorry.
Do you think we should ask you for an explanation from the Secretary of State?
Sorry.
And then the final point I was going to raise was that we anticipate the court may want an explanation as to how it is that the Section 8 application was made.
Acoustics in this quarter better than they were in the old courts. You probably
That's
heard.
what I
That's
just
exactly
asked,
what Lord
actually.
Junior said to me.
I thought we might.
Explanation.
Yeah.
Well, what those are the. That's all you wanted to
Well,
say.
yes, and just in respect of the explanation, I'd note that we asked in our side letter of Friday evening for an explanation. We've not yet had one. It's of course a matter for the court how it goes about seeking an explanation, but one option would be to require the Director General of the Government Legal Department to provide a witness statement.
Okay.
When you say Director General, is that the old-fashioned Treasury Solicitor? Is that what they're now called, Director
Yes,
General?
I think they are.
Okay. Thank you. Anything else, Mr. Butler, from you at this stage?
Thank you.
Now, does anybody want to say anything in reply in open court before we'll step outside in a moment to consider this, what we do next? But do you want to say anything in open court in reply, Ms. Laing?
Only, my lord, in open to apologise for the lateness of the disclosure. And there's no more I can say.
All right. Do you want to say anything in open before we retire for a few moments?
Lord, no.
Okay. All right.
I'm so sorry, but before the court rises, I appreciate it may be impossible for my learned friend to say more, but it would be useful for our side to know whether our interpretation of the note is correct, and that indeed this material is relevant to the substance of our grounds.
What I would suggest we do, Mr. Butler, is that if we conduct a closed hearing, we'll try and elucidate as much as we can, which can be revealed in a further hearings today with you back.
Thank you very much.
Rather than try to inch our way when none of us, neither you nor we, know exactly what's involved.
Yes.
Okay, right, we'll be back in a few moments. Thank you.
Right, so look there.
I just didn't know whether he's actually had time to, because I know you're constituting reconsideration.
Sit down if you want.
Actually had time to do things.
You know,
A few more times.
I'm just wary of the
They're not expecting us to clear out now, are they?
They'll come back in and say something in open whatever else happens.
Is this a closed court? They can't use this court. They haven't thought about that, but they can.
Just to remind you, the live stream is still on.
Thank you. Can you watch this right now? Or do you have to wait a few days? And then it comes?
Live streaming presumably means you can watch it right now. The idea you dial into a YouTube channel or something like that to get the live stream,
Oh,
the way
there's
it
just a
works.
button to press here and then it goes into live stream.
but to watch it.
Yeah, it's just on
To watch
YouTube.
it,
just-
yeah,
yeah.
there's a link.
Yeah.
There's
Yeah.
a link on the course list.
You're not an avid viewer, of course, with your YouTube
I'm
channel.
not tuned into the Supreme Court.
The thing is, Chris, when we're in action, it's always enclosed. There's nothing to watch. Wait for the closed version.
Doesn't even get a courtroom artist.
Just a blur.
Yeah, they sort of, yeah. Pixelate us out.
It's somewhat ironic that it forces you to explain exactly what's going on.
For some reason, which is bizarre, problematic, isn't it? It's the motion.
Go first.
Well, Mr. Butler, what we're going to do is we're going to go into closed session to consider the Section 8 application. And I'd like Mr. Ahmed's and Ms. McGahi's help about the logistics about that. Is this a hearing we could conduct in this court? Obviously with a live stream turned off. Or is it a hearing we should conduct in one of the secret courts?
It does require a closed court, my lord.
A closed court, okay. We don't know whether there's one available today, so we're going to have to make some inquiries about that now. What other suggestions do you have about the logistics for this? We haven't read the closed material yet. We've had 3 copies delivered. Would it be a good first step to read that?
It would, please, my lord, yes.
Okay, fine. So we need to, so what we could then do is rise to see if we've got a closed court available today. I hope we have. And then to read the material. We think we could probably, well, I was thinking 11:45. Or is that optimistic, do you think?
I don't know.
Milady has seen the material without reading it,
Certainly.
I've seen the files.
seen the files.
And obviously, my lord would be grateful if in open nothing was said about the volume of the material. It's a matter for your lordship. Of course, it's not also just a closed court that's required, but closed appropriately cleared staff.
Yes, yes, that's right. I'm aware of that. So we'd have to make inquiries about that. So I think what we'll do is we'll rise, make those inquiries, and then let you know what the position is. Mr. Armin, do you want to say anything?
Well, we've prepared a closed note. Might we send that to you and you to consider at the same time, or would you like it separately?
What do you think?
If they've physically got it, it's better.
Have you got it physically?
We can, yes, of course. We can
We can
provide
take
it.
it away.
Have you got hard copies
Yes,
in this room now?
yes,
Okay.
Quicker than
Well,
sending.
could you let us have 3 copies of that?
yes.
Right. Anything else? Anything else?
What would you like us to do, my lord?
Um,
Should we stay?
Don't go too far away, Mr. Butter. I don't think to take the day off. I don't take the day off. I would go back to chambers and wait for further developments. I think would be my suggestion. Agreed.
Yes, can you make sure that we've got a phone number or something to
Yes.
contact you?
Have we got a phone number on the?
Take that with us.
It's on this sheet.
What's on that? Just as long as we can get hold of you.
You're not very far away, are you? All right. If we'd like to do the hearing today, if we can. If we can't do it today, then we'll have to have a briefing. Okay. If we're in that position, we'll come back and talk to you. It will be an open court, with or without Mr. We'll probably ask you to come back then, Mr. Butler. Okay. Right. Anything else? Yeah. Sorry. Can you make an inquiry about
Am I allowed to leave these things here? I suppose it's not going to be your call. Yes. But then we might end up sitting in the
Yes, we work out the
tight
Yeah.
closed court in O2.
Yeah.